just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Yeah. Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay away. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, there'll be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jen McCabe, or Jennifer McCabe, I should say, revealing this link meeting, that report wasn't provided to us.
Okay, can you hear me now? Okay, I get it. I get it. How long have I been going? I've been going for 12 minutes. Has it been since the beginning? Wow. Okay, all right. All right. So what happened is, boy, do I have a lot to talk about today. Let's talk about the hearing today with these fraudulent, lying lawyers for the defense. Unreal. So what's happened in this case, and it's been a pattern all along, is that the defense says that they have no discovery to hand over. Either that they've never talked to the witness before, with Dr. Russell, who, by the way, I have a song about, was requested today for you. Or with the ARCA witnesses, they said we couldn't hand over discovery with the ARCA witnesses. This is David Yannetti, Alan Jackson et al. We can't hand over the discovery with the ARCA witnesses because they were hired by the feds and we only can talk to them for purposes of arranging their testimony. And so the judge Cannoni said, what, you're telling me that you're going to put on 3 people on the stand that you've never talked to? David Yannetti says, that's essentially it. Turns out, February 18th, that the defense does hand over some discovery. And there we find out that these ARCA witnesses, who were really the best thing the defense had, because they could say they were independent, that they did these independent studies. We knew that there were things that there was very sus about them, like that they testified that if they got more information, it wouldn't change their opinion. That's odd for someone who says they're a scientist. No. I thought Adam Lally did a good job on cross with them. And if you listen to Ronnie, the juror, he says that people weren't convinced by the ARCA witnesses because they thought they were being paid. Strangely still, even with the way that Alan Jackson made a big song and dance, you're not being paid, and the ARCA witnesses lied and said, oh, we're not being paid. So they brought in this perjured testimony. Nothing happened about that except a slap on the wrist. And again, they're still not handing over discovery. So I thought I was going to spontaneously combust, or Hank Brennan was going to spontaneously combust, because this is the worst judge I have ever seen in any case, criminal trial ever. She has no control over her courtroom. She's like another wing of the defense. And so I've heard people on this side of the fence say, well, she's fair because the Free Karen Reed people are angry and think she's biased. And I've heard people on this side, like me, say she's biased. But how much lying and nonsense do you allow to go on in your courtroom with no consequences? So then you become an accomplice, right? So I think my answer to that, to the people who say that she's fair because we're both unhappy, first of all, Free Karen Reed is going to be unhappy unless the judge rules 1,000% of the time with Free Karen Reed. And especially, they didn't say that last trial, we didn't hear about Judge Cannoni being so biased, because she essentially did rule with the defense 99.9% of the time. It's only this time, when the Commonwealth is winning a few motions, that we hear about Judge Cannoni being so biased. But any other judge would throw out Alan Jackson, David Yannetti, Robert Alessi, Elizabeth Little out on their behinds on the courthouse steps. This is absurd. It's like we're watching the Wild West. It looks like Massachusetts is a really good place if you want to kill someone. Go to Massachusetts. You want to kill your wife, anchor down her body with rocks, throw her in a lake, you might get mandatory involuntary manslaughter in a light sentence. You want to reverse into your police officer boyfriend 24 miles an hour in reverse with your foot 75% down on the pedal? Go to Judge Cannoni's courtroom. You won't do much time. It frightens me is this woman's going to sentence. If on the slight chance that Karen Reed gets convicted of something, Judge Cannoni's going to sentence her. It's scary. She's so poor. And so what we saw today in court was Hank Brennan just begging for fairness, just basic fairness. And this is something that we've seen. It's like deja vu. And every time that we have this deja vu where Hank Brennan begs the court for discovery, the other side for discovery, like he's handed over and he's met his discovery obligations, and Adam Lally and Laura McLaughlin too, the whole Commonwealth. The defense makes it really personal. Well, Hank Brennan just doesn't want Arca to testify. That's why he just got a problem with Arca. It's like a liar's argument. And this happens every single hearing. There's still no Arca discovery, and we're set to start with opening statements next Tuesday. So I'm starting to join the Free Karen readers in saying that maybe Massachusetts does have kangaroo courts. This is wild, not for the prosecution, but for the defense. So pro-defense. You can lie to the court. You can lie to the public. You can bring in witnesses that will lie to the jury, and then they'll invite them back, like Judge Cannoni did with Arca witnesses, to lie again to the jury. I mean, it's really like, what's going on with our courts? Just hand over discovery. No, they want to sandbag the Commonwealth. It sounds like Arca's done some new testing with stuff that they've never seen before, which is the defense's tactic all along. It's frightening. Yeah, I find it super frightening. So let's go to the February 18th hearing. Give me a second to pull it up. Thank you for your patience. I had to boot myself, so here we go. So just want to go to the end of this. So he's begging for discovery around, I remember it's like right around here.
Uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides, and that should not change. It's going to.
So does everybody know what discovery is? It's whatever you have. Whatever you have to hand over to the other side so that they can properly prepare. Now, we like to think of this in terms of a Brady violation. I think everybody's heard of a Brady violation. When the Commonwealth or the state or the government, if it's a federal case, withhold exculpatory evidence from the defense to win their case, to cheat to win. That's what it's about. And there's been so many bogus Brady claims. That's one of the things that innocence fraudsters use, things that really wouldn't be exculpatory or helpful to the defense.
Create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it will be abided by.
Okay. Was there any follow-up to that, the motion?
So just to skip forward.
Basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this.
Right, so they wanted to attach Karen Reed's case to the Birchmore case, but it goes on, and here he starts talking about the ARCA witnesses. I believe it's around here.
You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week. And I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. We'll move on.
Helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
So does everybody understand what's going on? There is a pattern with the defense to ambush the Commonwealth by saying that we just met this, we just found this witness, like with Marie Russell, the dog bite expert, who I'm not even sure was that story is even true, that she contacted John Lewin, who I've interviewed many times on this show, friend of the show. And he got me in touch with Alan Jackson because John Lewin works in the prosecutor's office, Los Angeles, with Alan Jackson's wife, if that's even true. She could have contacted the defense directly. And they could have made up the story. There's so much lying going on with and they said, we just haven't talked to her. We don't know. So then they had to voir dire, meaning both sides can ask questions in the middle of the trial. That's how the prosecution prepared for Marie Russell last time. In the middle of the trial, they could ask her some questions about her dog bite knowledge, which really her knowledge is really on police dogs and bite and hold, not so much pedestrian dog bites, but okay. I don't think she should have been a witness in that case. I don't think she should have been a witness in this case either. Ditto, but more so, I have an issue with McNasty Green, the defense's witness, computer forensic witness, whose opinions are totally debunked. And now we're going to have the jurors argue over things that are like, is the earth flat or round in the jury room? Because the 227 Google search has been so debunked. But of course, Cannoni let it in. All right. So then we have the ARCA witnesses who said they didn't talk to either, because they were hired by they couldn't talk to them because they were hired by the feds as part of the federal investigation. They made a big song and dance at trial that the Commonwealth could have used them, had the Commonwealth wanted to. Anyone could have used them. Their opinions were totally independent. They weren't getting paid. And here is where Hank Brennan shows the court that in fact that they not only were getting paid, they were retained, and that their testimony was scripted. So not only did these witnesses perjure themselves to the lie under oath to the jury, Cannoni's like, please come back into the courtroom for a second time so you can lie more under oath to the jury. And she stops this hearing and says there's going to be grave concerns for the defense. She asks Karen Reed whether she wants to keep her lawyer. She says yes, and she's warned that it's going to be hard to appeal under grounds of inefficient counsel, but she will anyway. If she gets convicted anyway, she will anyway, but she's been warned because they're acting so beyond the bounds and the rules of their profession. And Adam Lally gave the same warning in his filings in the first trial, that these lawyers are acting so beyond the bounds of the rules of their profession that I want to give a warning to Ms. Reed that these lawyers aren't acting like lawyers. Essentially, they're acting like con men. I'll say it. They're acting like low-life grifters in the courtroom. And Judge Cannoni's letting it go on. So here's where Hank Brennan exposes the ARCA witnesses as biased, paid for, retained, paid for witnesses. Everybody get what's going on? Okay, I hope so.
Your Honor said, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed the TUI letter, comprehensive TUI letter. And it was delayed in over a long period of time with requests and deadlines. I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me.
Whose wife joined a Free Karen Read Facebook group right after he testified. So they're turtle riders, essentially.
This morning, pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
Whatever changes you feel necessary. So, I mean, they worked in cahoots, right? So Alan Jackson today, it's like we never heard this. This never got exposed. What happened was, skip to the chase. The judge called a recess, came back shaking, saying this will have grave concerns could have grave consequences for the defense, something like that. It's not word for word. And the grave consequences were that Karen Rita asked if she wants to keep her lawyer. She said yes, and they got a talking to. These guys should never be allowed to practice law again. And then they file another motion after this saying that they weren't paid. Again, they continue to present this like they're not paid. We can't talk them. We can't hand over discovery because of the federal investigation, which is over. Because ARCA is now working on new fraudulent stuff to come into court that they want to sandbag the Commonwealth with. And Cannoni's letting this all happen. And Hank Brennan was saying today in court, hey, look, the reason I've said this since I've been in court, I need discovery, is so that this wouldn't happen right before trial. When we go to court Tuesday, how am I going to prepare in the middle of court? How can I talk to my experts about what their expert findings are and refute them if I don't know what they are? But the defense, because they have so little, has to cheat to win. I'm just, my head is exploding at what I'm seeing in this trial. It's so beyond the bounds. I've seen a lot of fraudulent stuff done post-litigation, but not pre-trial and during trial, and pre-retrial. And our press is reporting it on it like this is normal. This is that the defense attorneys are just putting on a vigorous defense. This is not a vigorous defense. This is a fraudulent defense. And I have come under fire saying this since the beginning about these defense lawyers. And my critics on both sides of the fence, On the Free Karen read and the non-supporters all say, don't listen to Roberta Glass. She's just a cheerleader for the Commonwealth. Well, I have to say, I've been 1,000% correct about these lying, fraudulent, scheming, con artist lawyers. So let's look at today's. Should we take a break and look at the... No, I think we should go right into today's hearing. If I don't explode. Hopefully I won't explode. Hopefully I won't spontaneously combust. It's just really hard to watch something so unfair. You know, our court system is based on basic fairness. And it just seems like we have a judge who's another wing of the defense.
What has been provided and what you might think has not been provided.
There are two issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these...
Right. It's not in our custody and control to have them bring their own reports that we probably have. This is a deliberate ambush of the Commonwealth, what we're watching here. We're watching fraud in real time.
Items I expect would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to the February.
So does everybody get what's going on? So it's worse than just saying we're not going to hand over our discovery. We're going to take the Commonwealth's discovery, and we know that ARCAs are just like our puppets, defense puppets, and they'll say anything we want. We're going to get them to rebut the Commonwealth's testimony, but we're not going to say what that is. So the Commonwealth can't head it off with their own experts or even know the right questions to ask. Hank Brennan is not as much of a Superman as we all think he is, and Adam Lally and Laura McLaughlin. They're not experts in everything. Biomechanics, et cetera, et cetera. How are they gonna rebuke that? Please hit the thumbs up before you head on out. But how are they going to refute it? I mean, this is just so maddening to watch. It's like, speaking of, I hate to use this analogy, but it's really like watching a car crash in slow motion. Because we count on a basic level of fairness in our court system. And sure, the Commonwealth doesn't have the volunteers from the Ivy League with the Rhodes Scholar volunteers or the pro bono extra lawyers or the Hollywood lawyers or the high profile Massachusetts lawyer like David Yannetti, who's handles every killer and predator in the state practically represented. But they have the truth. But when when the defense puts the thumb on the scale so much, what is the outcome? It can only go one way, towards Karen Read. She knows this. This is why they're doing it. They have to cheat to win. And Judge Cannoni's like an accomplice. She's like cheering on Karen Read. How can I help out Karen Read? Well, I can have a voir dire at the last minute. What is the Commonwealth going to do with that? That's what she did last time. She kept out all of Karen Read's own statements. Why? I mean, once you give up your right to remain silent and not self-incriminate, why weren't those statements allowed in last time? But we sure kept the free Karen Read people off her back.
For a 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my 3 requests.
Here's Amnesia Jackson, as if it's never been revealed that the ARCA witnesses have had extensive dialogue with the defense, that their testimony was crafted by the defense, that they were retained and paid for by the defense. And that they've had this habit of holding back evidence from the Commonwealth in order to sandbag them. They've shown a pattern of doing this all through the first trial, now all through the second trial. Amnesia Jackson's going to get up like none of this has never ever happened, and that we're still back thinking that the ARCA witnesses are independent witnesses hired by the feds that the defense can't talk to, and they can't hand over a discovery for that reason. And Judge Cannoni, no pushback. And I didn't see Peggy O'Keefe. Did anyone see Peggy O'Keefe in this hearing? Where are the O'Keefes? I see John O'Keefe's friends, but no one else. Where are the O'Keefes? Does anyone know? Do they just lose it? Can they not take it anymore? I would understand. I'm about to spontaneously combust watching this.
I want to go in reverse order briefly, if I could, concerning the discovery deadlines. We have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, the reports, amended reports, redacted reports, additional information. Both sides understand.
Well, that's only a plus for the Commonwealth. So he's saying, so when you hand over finally hand over all the discovery that you have, meaning all the evidence that you have that you're going to use at trial, to the other side, you file a certificate of completion. So long ago, long ago, the Commonwealth did that. But other things have come in, and some of these things we've seen are anonymous reports, anonymous tips. We don't know what they are. They could be crazy people. To Hank Brennan, you know? Make sure you talk about blah, blah, blah. I think John O'Keefe was abducted by aliens. We don't know what it is that he's handed over. But let's just say that it's important or something extra that's come in. That only speaks well of the Commonwealth that they handed that over immediately. So Alan Jackson's going to say that with all they're preparing for trial, they don't know what they're going to say to the Commonwealth's experts, to a report that was given to them long ago. So they can't hand it over because they don't have it. Were we all just born yesterday? And then he's going to go into the federal investigation nonsense again, if my memory serves me correctly.
Understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice.
So this should tell all the free Karen Reed people that the federal investigation is over. So we weren't allowed till March to really talk to them, even though in February, Hank Brennan showed to the whole world and the court that they'd been in communication, retained, that they didn't care what the federal investigation was doing, that they were going to talk to these ARCA witnesses and make them puppets of the defense no matter what. They're hired guns by the defense. Does Free Henry not get that? But no, we just learned in March 26th that we could talk to them. I mean, it's insulting. And the judge just listens, says nothing. Not, excuse me, Mr. Jackson. I said there would be no more lying and misrepresenting. I'm not even, she doesn't even use the word lying. There would be no more misrepresentations of facts. Every euphemism for lying in this court. She just lets it happen again and again and again.
That we could.
I mean, if anything good comes out of Free Karen Reed, is that next time Cannone, she up for a vote? Does she get voted in? She's up for a vote. I hope she gets voted out as a judge. This, in New York, our judges are like, there's nobody's running opposed. So it's basically they come in, there's no one to vote against. There's just like, here are the judges that are running. Pick 3, and 3 are running. So there you are, you have it. And they're all Democrats.
We, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate there too. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if
this is another technique that sleazy defense attorneys do. They say, don't write a report. This is also why Marie Russell had no report. All right, I'm going to just take a quick break. I need to cool off. I'm going to just play. Here's my Marie Russell song. Who asked for the Marie Russell song? I can't even remember who asked for it. I think this might be a good time to play it. I know it's a little like ADD theater, but I need a break. I need a break from AJ.
Bored and retired, threw myself into a high-profile trial, thirsty for attention and admiration. I'm the best expert in the entire nation. Get paid to lie by the hour, making stuff up is my superpower. I see dog bites. I see dog bites. Just pay me and I'll tell you they are dog bites. Limp to the stand, decked out in polyester. Lay my lies on the court and let them fester. Puncture wounds in the shirt. Testify
That's the Marie Russell song. Okay. That lightened the mood a little. This is like, to anybody else, I felt it in the chat after this hearing. I felt like we were all going to just spontaneously explode. Thank you. Oh, it's too much. Like how can the it'll be like a miracle if there's like a just verdict in this case. It'll be a miracle. Thank you. That's your new favorite, Maestro. That one was not easy to write. Not easy to write. I was trying to get in a lot of her weirdo lines, like, to a great deal of medical certainty, to a reasonable degree of medical certainty. I was trying to get that in. I got it in, but needed a lot of editing. All right, here we go. Back to today's hearing. Here's AJ. The tiny man himself. Elton John, Tiny Dancer? He's Tiny Liar. He's the tiny liar.
They are. Once they get it, we'll turn it over. That's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13. Another party says, we gave them to you. And then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse different pieces of my discovery request, but we do not have all the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
the
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So address number one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have They have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about.
It's like it's like deja vu all over again. We don't have it. We can't talk to them. They have everything we have. We heard this last time. It was a lie. Judge Canone's like, please lie to me some more, defense team.
Etc. We could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on.
We know that's a lie, Alan Jackson. That's already been proven untrue. We've seen the evidence. We've heard the emails. You were obviously talking to ARCA before March 26th, 2025. Why doesn't Judge Cannone say this? I'm not even a lawyer, nor a judge. And Judge Cannone's like, Mr. Jackson, please lie to me some more. Please put some more of those lies on me. What a disgusting person Alan Jackson is, and David Yannetti. Maybe, you know what, maybe in court, maybe when this goes to trial next week, maybe just lightning will strike them in opening statements. It's like if their mouth is moving, they're lying. It's wild. It's wild to watch.
March 26th, 2025, we immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately.
Wait. It's only been a few days since March 26th. It's April now. This is what? It's only been a few days since what? None of this makes any sense.
And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that if the court's satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination.
No. Let me clear this up. The judge is not an idiot. She's not bamboozled. She's not fooled. She was a former defense attorney representing the worst of the worst. She is hopelessly biased. She did all these tricks that the defense did. She's a fraudster herself. And they all know it. They say things to her like, you get it, Your Honor. You get it. Roberta Leslie said that to you. You get it, Your Honor. You've been there. You get it. You've done this stuff. You withhold discovery before, right? From the Commonwealth. You get it. She is ideologically, spiritually aligned with the defense. She's a fraudster herself. Because anybody, even if you were, say, like, prejudiced a little bit more to the defense, who's a judge, would like to see would make sure that their court was a fair court, not Judge Cannoni. She'll help the defense get off hook or crook, which is probably how she got off her clients, by hook or by crook, fair or unfair, cheating, or cheating to win, same stuff.
Is that clarified any better? They say,
I mean, you know, Free Karen Reed should be very, very concerned. Everybody who cares about our justice system should be up in arms, whether you want Karen Reed to get off or not. Because this is a kangaroo court. This is like what they're talking about, kangaroo court. This is a kangaroo court. Discovery not handed over, things hidden, juries lied to. That's the definition of a kangaroo court. Not following the lawyers, not following the rule of the law, and doing it over and over and over and over and over again. That's the definition of a kangaroo court. So it doesn't matter whether you support Karen Reed, don't support Karen Reed. She does not have a right to cheat to win. You don't. You don't cheat to win in this court. I would be saying the same thing if the Commonwealth were not handing over discovery. And it came out that some evidence that some expert witnesses that the Commonwealth had that they said were totally unbiased were in fact paid for, retained, paid for, crafted their testimony. I mean, these are like the people that defend like Lance Armstrong.
said we. They talked about we did this, we did that.
Well, I would disagree with
I'll give this to them. It makes it much more exciting to watch. To watch these lawyers just lie, cheat, and steal to win. Certainly isn't boring. But this is not entertainment. This is our justice system. There's a man who was murdered in a family that desperately need justice. Not to mention all his friends and everyone who loved him. And this is the way that the Massachusetts courts are. This is what's going on in Massachusetts courts. It's wild.
Dr. Rinchler talked about what he did, which was more on the biological side.
There was a difference between the
and
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
He's pretending he didn't talk to his own witnesses, that they're not preparing for trial that starts next week. What?
Right. Ms. Liu I was getting to the point, but she emphasized, and I will emphasize it here, The one thing that the US government has said to both the Commonwealth and to us is, in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the US government and the Department of Justice.
But can they testify as to what they did?
Yes, that is on. That's
Can
on the
they
table.
testify under what direction they?
Yeah, but that's not the issue. We've already been through this. The issue is that apparently you're having them do new tests that you haven't gotten yet, which I don't believe you haven't gotten yet, Alan Jackson. I don't believe you're not talking to them. Wouldn't you love to see Alan Jackson's phone records with ARCA? How many phone calls do you think there are with ARCA? I'd say many. And they're not all after March 26th. This is just absolute nonsense.
Did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Council Tagger?
Yeah, I was disappointed this was done at sidebar too. All right, I'm going to take a quick break. When we get back, Aiden Turtle Boy Carney takes the fifth. Takes the fifth when we get back. Don't go anywhere.
Mic check, Roberta strides through the static haze. True crime Gotham where the shadows play their plays. Fraudsters fold when a spotlight beams. Fact focused queen busting propaganda schemes. Glass shatter lies echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing she's the anti-fraud light. Hard task warrior, dissecting state and defense. Twisted innocence, claims breaking pretense. Gotham's truth seeker cuts clean with the blade. Facts in the forefront, no justice gets swayed. Cold facts drip heavy, real talk unfurls. Cracking cases open like oysters with pearls. Innocence gimmicks crumble to dust in the wind. For victims, her creed, justice till the end. Headphones blazing, she drops heavy artillery. Narratives twisted, meet blunt object civility. Roberta got receipts that unravel the ploy. Exposing the lies these fraudsters deploy. Glass shatters lies, echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing she's the anti-fraud light.
Okay, I'm back. I'm with you, D. Help, I'm literally at the point of not being able to take this anymore. Karen is 100% guilty. There isn't a plethora of reasonable doubt. Not reasonable doubt. It's not reasonable. They're throwing out things to make it doubtful, but none of it's reasonable. Feels so abusive. Yeah, welcome to innocence fraud. D, this is how it goes. This is what I should have called my channel the Feel Bad channel, the Feel Bad True Crime channel. Horrible stories of injustice. Welcome to my world. It's awful, right? It feels so abusive. These lawyers. It's these lawyers. Now we know why Shakespeare said first kill all the lawyers, right? Feels so abusive to the family, friends, and witnesses. It does. You're right on the money, Dee. I'm with you. I'm with you. We're all a support group here. It's hard. It's really hard to watch. Let me talk to you all in private. It's also the narcissism of Judge Cannoni, too, right? I don't want to embarrass you in public. I'm just going to call out your lies in private. I mean, I don't know what happened in private. I would think that's what happened, but who knows? So let me move through this. This is okay. So Alan Jackson comes back with some more lies for the court. And Hank Brennan just looks like he's going to explode.
All right, so Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent.
So they're saying they're not going to have anything new, given that the new Commonwealth's witness. Didn't Hank just mention that they have new ways that they're going to try to rebut the Commonwealth's witness? Did he not just say that? She's like, oh no, it's all old. So what's going to happen in court when they testify to new things? Nothing, right? Because they know Judge Cannoni's not going to do anything.
To that, information was provided by Mr. Yannetti. And you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information?
You know that that's not true. So there is an email. The reason I know this is untrue is because there's a text message from Turtle Boy to Lindsay Gattani, who he was dating while he was married, that says that Josh Levy of the feds does not want the public to know that we are working with the defense. So anything that anything that the feds gave to ARCA was cherry-picked by the defense. So this is another lie. Another lie. And with their conclusion that John O'Keefe couldn't have been hit. The damage to Karen Reed's car could not have been caused by hitting John O'Keefe. And that they didn't need any more information from anywhere. And that they weren't given the most damning evidence against Karen Reed. That it was cherry-picked by the defense to get the results that they wanted. It's another lie.
Information was provided.
Yes, it's in the report. There
All
were
right,
14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include.
Right, a narrow scope, so that they could come up with the answer that damage to Karen Reed's car could not have been caused by hitting John O'Keefe.
The myriad things that we were getting in NODs.
All right, then
from
you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when
that's
did you
what
do?
we provided to them?
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26th, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said, I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right,
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
all right. Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between.
I mean, and here's Hank Brennan saying, look, this is exactly why I put in these motions to preclude ARCA as witnesses. He said, I'm happy to have them as witnesses. I just need the discovery. That is your job, Judge. Just to keep things fair. Just to make sure both sides have the information they need to go to trial. What is going on? I mean, you would have thought that Judge Cannoni was, I mean, the only time I've ever seen a judge like this, actually I have seen, since South Africa, was in Reva Steenkamp's murderer, Oscar Pistorius' trial. And that judge came up, so they don't have a jury. Just goes in front of a judge who decides, and her decision was so wacko that it was eventually overturned because it didn't follow the rule of law. It was so whacked out. And she ran her court more fairly than this. And her decision was way overturned, easily, in appeal, because it was so biased towards the defense. Manny, thank you very much. Show is listener supported. I appreciate it. Allows me to do these episodes. Says Jackson is awful. Just lies and deception. No shame. No respect for the rule of law. 100%. Yannetti's the same. Elizabeth Little's the same. Robert Alessi's the same. They all come from the fraudster school of law. I mean, it wasn't a surprise to me to hear that David Yannetti was overturning convictions that had been done years before on hearsay, nonsense evidence involved in this movement, the wrongful conviction movement. So fraudulent. And these guys should never be able to practice law again. I don't understand. I don't understand how Judge Cannoti still is allowed to rule her court this way. It's wacko.
Between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds, it's not in their possession of control. That's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructions they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for.
So Dee, the woman in, it's not going to help the people listening on podcast, but the woman in a coral blouse with the blonde hair, that's Meredith O'Neill, who is Aiden Turtleboy Carney's girlfriend. I believe he's still married. I don't know if his divorce has come through yet. I don't think so. But she just had a family member murdered by a drunk driver. The irony of supporting Karen Reed.
Our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until March or February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Your Honor, what appears to be feigned.
This ticked me off too, to call feigned indignation. That's not feigned indignation. That's like real anger. Feigned indignation is you saying, how dare you? Or what did he say to Proctor? Shame on you. There's feigned indignation for you, Alan Jackson. Oh, this made me explode.
Indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judge Welcher's PowerPoint were by exclusion. Attorney Alessi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing.
So does everybody get the difference? Does everybody get that? They're like, so they're saying, well, there were changes to their presentation because that was over objections by the defense. So they took things out. That's not adding in new things. That's not making new testing. That's not doing new reports. That's not hiding discovery. That's making changes to satisfy the objections of the defense. If anything, it's being partial to the defense. It's not putting you at a disadvantage. Oh, gosh.
Any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of the report. And
I'd love to know what those additions are. I'd love to know what those additions are. See how vague they are? There's been more additions to the report. Mr. Alessi says it's not true.
Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that
February 5th. Not the week before trial and after. It's not even a week before trial. They're saying maybe if it comes in the middle of trial, we'll get it to you. Maybe. We'll hand over our discovery obligations.
That's when we received permission to hire ARCA. That's when we received permission to engage.
That's when we, but strangely, they were paid right after they testified. And they were keeping track of their time. They were retained before that. So come on. Why doesn't Judge Cannoni push back on any of this nonsense?
Engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right. Thank you. I think the only thing left the motion to sequester Aidan Kearney to remove him from the sequestration.
Yeah, and just invite him into the courtroom, the witness harasser. The 16 witness harassment counts against him. He can sit in the court, except for the particular witnesses he were harassed, which I think is an absurd ruling as well. But he took the fifth. The fifth. So to give you a little, this is what happened. He says he'll take the fifth. Hank Brennan wanted Aidan Kearney to swear under oath that he would take the fifth if he was called as a witness. So who knows how much of the witness harassment stuff is coming in. I say let him take the fifth. Bring him up on the stand and let him take the fifth and let the jury figure it out. Why not? Let him take the fifth in front of the jury. Why not? All right, going to take one more break. When we get back, summing it all up.
Bored and retired, threw myself into a high-profile trial, thirsty for attention and admiration. I'm the best expert in the entire nation. Get paid to lie by the hour, making stuff up is my superpower. I see dog bites. I see dog bites. Just pay me and I'll tell you they are dog bites. Limp to the stand, decked out in polyester. Lay my lies on the court and let them fester. Holes puncture wounds in the shirt. Testified to a great deal, I'm certain. Hell, they'll say anything. It's the prosecution that's got the burden. I'm the best expert that's ever been. Who else can testify to a dog bite by a canine without a chin? Don't need evidence to state my claims. There's a lot of hounds in the world. One's got to be blamed. I'll do anything to get rich and get off killers. Pay me extra, I'll blame gorillas. I'm the best expert that's ever been. Who else can testify to a dog bite by a canine without a chin? Don't need evidence to state my claims. There's a lot of hounds in the world. One's got to be blamed. I'll do anything to get rich and get off killers. Pay me extra, I'll blame gorillas.
Okay, summing it all up. I don't know where we're going to go from here. I wouldn't be surprised if Karen Reed gets acquitted with the way we're going. With the way we're going. Acquitted or another hung jury. I'll be shocked if she gets even convicted of some smaller, lesser charge. Really? I mean, the cards have been so stacked in the defense's favor. But we shall see. It's been a real lesson in corrupt lawyers. Yeah, Lisa, if I have to kill someone, make sure I do it in Massachusetts. Great state to kill someone. Great state to be a murder defendant, certainly. So I'll see you guys all. Yeah, we've been going for a while, almost 2 hours. I'll see you all tomorrow at 6 p.m. Eastern. You didn't hear that? Yeah, I don't think I would kill someone. Let me reflect. Don't worry. I'll see you all tomorrow at 6 p.m. Eastern. Please support the channel. Get access to Patreon-only material at my Patreon. Buy me a coffee. Best bang for your buck is send a donation via Venmo. All the links are in the description of this episode. Please hit the thumbs up on your way out. Thanks for listening. I'll see you guys all tomorrow at 6 p.m. Eastern. Have a great night, everybody.
It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment. I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit. Innocence fraud campaign is my biggest hit, yeah. My biggest hit, yeah.